With that, let's begin. I'm Bruce Hammer. Welcome. Today we're going to go over inspections and requests for repairs. Kind of a broad subject. Why are inspections, why are buyer investigations important? Well, we all know that as real estate professionals, we owe a duty of care to our client. Our client, whether they're buying or selling, this is more for the buyer side. But if you're representing a home buyer, they don't know the ins and outs of the process necessarily. I mean, they could be an experienced home buyer and they may have gone through the process before, so they might have a little more knowledge. But you're the expert, and so as the expert, and bearing in mind that we owe a fiduciary duty to our client to not only get them the best price under the best terms for their purchase, we have to kind of look out for them. And looking out for your client means, as an agent, as a broker, it means recommending that they do their due diligence during their contracted inspection period, to determine if they want to go through with the purchase of the property, and if there are any major defects or problems with the property that would make a reasonable buyer in the shoes of your clients want to maybe back out of the purchase. And so that's the reason we always recommend to our clients that they go and get home inspections. And I don't just mean home inspections, I mean pest inspections, roof inspections, depending on the neighborhood, maybe a sewer line inspection. If you suspect that there could potentially be some sort of structural problems, you're going to want to recommend a structural engineer's report, all these good things. Hold on a second. I want to add Reza to my attendance sheet.
Thank you.
You're welcome. And got that. So we got 1, 2, 3, 4, 5. All right. Now, failure to recommend your client get inspections could be construed as professional negligence, because you're the expert again, and you know that you can't always see a defect in a property just by looking around. So with that in mind, we have a few forms that we're going to go through and a little bit more explanation. And then if you guys have questions, feel free to chime in. If it gets to be too much, then I'll probably start asking you to hold the questions, write them down and hold them till the end so we can get through it. But at least initially, they should be fine. So this form right here, this is called a BIA, Buyer's Inspection Advisory. And, experienced agents like John will know that this is part of your Zip Forms library that you get as part of your subscription with CAR. And so these forms are designed by attorneys. They are vetted by attorneys. They are modified pretty regularly by those attorneys when they find things that could be improved upon or verbiage that might be better suited to be phrased a different way, things like that. So this particular form should be used in all buyer representations. This form is going to tell them why it is so important for them to get their various inspections and review the disclosures from the seller and stuff. It talks about us, broker obligations. And this is what I call our weasel clause. It states, brokers do not have expertise in all areas and therefore cannot advise you on many items such as those listed below. If broker gives you referrals to professionals, broker does not guarantee their performance. This basically, we're not contractors. We're not, engineers. At least most of us aren't. And so we don't have the expertise to go outside the scope of our license and make recommendations, that a property doesn't need a home inspection or that it's in perfect condition or anything like that. you can walk through with your client and say, hey, it looks pretty good, but you never know, things could turn up in the home inspection. Now, gives a very strong admonishment to your client. And you notice this is in bold capital letters. You are strongly advised to investigate the condition and suitability of all aspects of the property, including but not limited to the following. And then I love this line. If you do not do so, you are acting against the advice of brokers. So A through K here, actually through L, is listing several items that buyers should strongly investigate with the property. Will every buyer investigate all of them? No. Buyers aren't necessarily going to be going out and hiring somebody to investigate soil stability, unless, of course, your house is on a precipice overlooking Pacifica, California, or in Westlake in Daly City or something like that, where it's an old Dolger home and you're built right on the cliff or close to the cliff. Then soil stability might be something to look at. But here's the thing about this. In writing, we are saying you are strongly advised to investigate. Now, sometimes what agents might do, because they're trying to help their client, they know their client may not have a lot of money and stuff, and what they'll do is they'll go through this form with the client, have the client sign the form saying, yeah, we agree to this, and then there's kind of like this wink, well, the house looks pretty good. I know I'm telling you that you should get a home inspection, but you really don't need to. You should never, ever be in a position where you are doing that with a client. You need to be strong. You need to have them read, review, and sign this form. And your mantra throughout the entire transaction and conversations with your client should be, I absolutely recommend you do a home inspection. When I moved to Sacramento, I bought a brand new home and I paid for a home inspector to inspect my home before it closed escrow. Now, in my case, it probably wasn't worth it. All they found were a couple seals blown on a couple dual pane windows, which the builder would have taken care of anyway. But I like to get a second opinion. So, anytime you're dealing with a buyer, you can't be talking out of both sides of your mouth when it comes to getting inspections. You need to recommend they get the various inspections, and you need to have them sign this agreeing to do so. The way I would phrase this to you is, imagine, if you will, and you'll have to forgive me, but when I review something for risk management reasons, I always look at it under the guise of, if something happened in the sale, if something happened with the property after it closed, I look at it in terms of risk management and what would happen if I were an agent being deposed by a plaintiff's lawyer. And I'm sitting there and the plaintiff's lawyer says, Mr. Hammer, I see you had my client sign this buyer's inspection advisory, telling them all the reasons they should get a home inspection and a pest inspection and all this other stuff. Is that true? Yes. Well, Mr. Hammer, isn't it true that at the same time you were having him sign this form, you were also telling him that, gee, my brokerage makes me get this form signed, but I really don't think you need to get those inspections. And as soon as they hit you with that, you're sunk, because basically that defeats the whole purpose of you going through the motions to have your client acknowledge that they should do these inspections. So never talk out of both sides of your mouth. Yeah. That will come back and bite you in the rear in the future.
Ambrose, question.
Yeah.
Isn't it also with new homes, sometimes the builder has, like, let's say 2 years to cover any defect or anything that you want to catch that right away? And, well,
I can't say what the exact new home warranty is these days. I thought it was closer to 6 years.
Oh, is that what it is?
Yeah, I thought it was, but it could be longer for all I know now.
But
John, you're on this call. Do you happen to know what the new mandatory builder warranty is on new homes?
2 years.
Is it? Oh, it is 2 years.
uh,
Okay. All right.
Yeah.
So there you go. You have the answer.
thanks.
Okay. So anyway, some of the various types of the more common inspections that you're going to want to recommend your client get: home inspection, pest inspection, roof report. And if you know, you can throw this one in too, a sewer line inspection, but definitely throw it in if you are in an area. Let's just use Land Park, for example. Any of those homes where you have a lot of old established trees. I'd even argue, at least around my house in Natomas Park, I think a buyer of my house would probably want to get a sewer line inspection, just because there's a bunch of big trees. You know, all of our neighbors, we now have these 20-year-old mature trees there. So, and trees, the roots and stuff, they can get into the sewer lines and cause problems. It's well worth it if you're representing a buyer to recommend they go through that cost just to be safe.
Excuse me,
Sewer
Bruce,
line
can I
pipe.
just say something?
Yeah, John.
2 years is standard for new homes, but the roof and structure is 10 years. Some builders only have a 1-year warranty on everything. So it depends on the builder, but
Right.
normally it's about 2 years. Roof and structure is 10 years.
Thank you,
Just
John.
wanted to correct myself.
Appreciate you. All right. Let's see here. All right. So this form, like I said, it lays out a number of these, and this is the buyer inspection advisory. It lays out a number of recommended types of inspections that people can get. You know, some of these are actually going to be covered as line items in your natural hazard disclosure report. Fire hazard, not fire hazard, earthquake and flooding, environmental hazards, things like that. Square footage, age, and boundaries. So let me just give you my feedback on that. Normally, of course, the tax records state what square footage they believe a property to be. And then oftentimes, and whenever I listed a property, I would always go use what's called the assessor autofill. So whatever the tax assessor says, I would have that autofill into my listing agreement. So that's what's being displayed publicly. However, sometimes a seller will have their own appraisal, and their appraisal says that the square footage in the tax record is incorrect. Therefore, I want you to use the appraiser's square footage. So you might have that thrown into the mix. I can tell you when I sold HUD properties, HUD would require that we modify the tax records to show the FHA inspector that they use what their appraised square footage is. So you can have a few different variances. As long as you state where that square footage comes from, you should be okay. Now, if your seller says, I have an appraisal that says my square footage is X, but the tax records say something different, then you're going to want to see or get a copy of that appraisal if you're on the listing side before you list that in the MLS. Regardless of what is in the MLS, if you're representing a buyer and they're getting a loan, they're probably going to have to get an appraisal done. And that appraisal, just know, that might come out with a different square footage depending on how they measure. And that happens every now and then. Let's see here. All right. So this form, and one important one, rental property restrictions. So typically you're going to see rental property restrictions. They're going to be noted in HOA documents, things like that. State of California has a law that says HOAs have to allow a reasonable percentage of rentals within their community. I see you smiling, John. that is under state law, and the state has defined a reasonable percentage of rentals as a minimum of 25%. They can go 30%, they can go 30, but they just can't go below 25%. And yes, they can really enforce that on a home buyer. So, and we'll talk about this in later and in other classes, but whenever if you're representing a buyer who happens to be an investor and they're buying in a condo complex or something like that, and you know they're going to be renting the property out, one of the things that you want to have them look into is when they get their HOA documents and their other disclosures, they're going to want to reach out to the HOA management company and confirm that they are able to rent their unit, and you will be within that whatever percentage of maximum rentals they allow. Because the last thing you want to do is let it close escrow, or you tell them that, well, gee, you know, the listing side or the seller has advised that it would be okay to rent this property. And then they close escrow and find out they can't rent it because it's already over the 25%. You do not want to ever be the person passing that okay back to your client. If somebody asks you something like that, that is not part of the scope of what your responsibilities are as a real estate licensee. Just like it would not be your responsibility to go to the building department and investigate for them whether it's okay to subdivide a property or whether they could build an apartment building there or something like that. You are very welcome, and I'm sure they would appreciate it if you would tell them where to go. They might even appreciate you coming with them and making sure they didn't miss asking a question. But you should never ever be the one who goes and does research and then gives that information to the client about what they may or may not do with the property. Because if you make a mistake, you have assumed liability for that mistake. Clear? All right. And of course, we want them to look at the neighborhood area, subdivision conditions, and personal factors. They're going to sign here and date it. And then this is a form here. This is generally required. It is required for any FHA transactions. And this would be in addition to getting the TDS, the trustee, the transfer disclosure statement, the SPQ, any HOA documents, your natural hazard disclosure report, and other disclosures, well and septic, test if that's required, whatever. But if it's an FHA buyer, you've got to get this form. It's called the HID. So it also says, for your protection, get a home inspection, blah, blah, blah. And it tells them that the FHA appraisers are not home inspectors. Although if you've ever been on the receiving end of an FHA appraisal, sometimes you think they're home inspectors. They go through everything with a fine-tooth comb. And if there's anything that is contrary to what they believe should be in operational condition in that home, they will not let it close escrow unless that issue is taken care of. Right? You're going to have them sign and date it. And then we have the buyer inspection waiver. And these are all kind of standard forms you're going to be using. But the buyer inspection waiver, if after your diligent convincing, your client just insists they don't want to spend the $550 or whatever it's going to cost them for a home inspection. They don't want to spend the $150 on a pest inspection. They don't want to do a roof inspection. Whatever it is, if after your diligent attempts to try to get them to do that, they still refuse, then they're going to sign this form, or they're going to initial this form and sign it. And this is a form that I can't tell you how often this has kept us from being involved in litigation. I have been part of this I rejoined KW in April of 2022. And I can tell you that there have been at least 3 potential pieces of litigation that I have managed to keep our agents and our office out of because the agents use this form, which they're supposed to use anyway, but because they use this form and had their clients initial and sign it, I was able to avoid any potential problems because of a defect that turned up after the fact. So make note of this BIW, Buyer's Inspection Waiver. This is a required document on most of our transactional templates that we use within Command, which is our transaction tracking system. This form, once again, talks to the buyer about the importance of investigating the property. It talks about the buyer's rights and duties, and it uses legal terminology. You have an affirmative duty to exercise reasonable care to protect yourself, including discovery of the legal, practical, and technical implications of disclosed facts, and to investigate and verify information facts that you know are within your diligent attention and observation. This sentence here is a direct method, or it's direct verbiage of countering a claim of negligence. And so it makes up a very important piece of this warning document. Waivers. Now, if they decide after your cajoling and your information and recommendations, they don't want to get a home inspection, you want to get them to initial here. And what they're initialing to says that the broker recommends that the buyer obtain a home inspection, even if the seller or broker has provided buyer with a copy of a home inspection report obtained by the seller or previous buyer. If you do not do so, you're acting against the advice of brokers. I want to stop here and I want to address this issue. There have been many times, and you will encounter this too, and I'm sure John can attest to this as well, where you're representing a buyer and you go into escrow, and let's just say that a month ago, that seller already had that property under contract. And while it was under contract previously, the buyer followed the advice of their agent and they ordered a home inspection, a pest inspection, a roof report, a sewer line, video inspection, all that great stuff. Well, the purchase contract requires that anytime our client orders these inspections and reports, that we give a copy to the listing agent. The reason that is necessary is because in the event that our escrow falls apart, that listing agent is responsible or required on behalf of their seller to give copies of those inspections and reports to any future buyer. I'm sorry, do you have a question, Riza?
Oh, no, I'm sorry. Yeah.
Okay.
I meant like to the new agent. Yeah.
Okay. So, so that listing agent would then have to give copies of those reports to the next buyer. And so a lot of times you're representing a buyer and you've just received all these reports that the previous buyer on that home had done. And your client's looking at spending $1,000, $1,500 on new inspections and reports. And they say, you know, we have all of these inspections or reports. Why do we need to pay for them again? Well, the answer to that is pretty simple. When your client, let me back that up. When the previous buyer paid for a home inspection, that buyer signed a contract with the home inspector, and that client paid the home inspector. So between the home inspector that previously did their inspection and that previous buyer, they had what's known as privity of contract. Meaning, if the home inspector makes a mistake, because there was a contractual relationship between that home inspector and that previous buyer, that buyer, depending on any waivers of liability that are contained within that home inspector's contract, that buyer may be able to go after that home inspector for negligence as to those mistakes that home inspector made. But let's contrast that with a new buyer on the property that is given a copy of that home inspection. They rely on that home inspection, don't get another one, and then they close escrow. And after closing escrow, they realize, oh man, that home inspector really messed up. The HVAC system doesn't really work at all, and actually the coil in the furnace is all rusted out and falling apart. And now I've got to pay $13,000 for a new HVAC system. That new buyer that relied on that inspection has absolutely no recourse against that home inspector, because there was no privity of contract between buyer number 2 and that previous home inspector. So when you are working with your client and in that situation where you are offered previous inspections, it is okay to rely on them in terms of supplementing your client's base of information on the property, but don't use them to replace a new home inspection that your client should get, so that they will have some level of protection, right? And I've seen 2 different home inspection reports on the same house, and they aren't necessarily going to look the same. Some will point out some things, some will point out other things. So use them to supplement, but don't rely on them as protection for your client. And that's the explanation you can give your client as well. Again, if they don't want to get their own home inspections, make sure they initial here. If there are any additional inspections, like a roof report or whatever, you can write those in here, indicating they're waiving those. If you have been given any additional reports from the previous buyer's contract, make note of them here, and have your client sign and date it here. Hopefully they won't be waiving a lot of inspections, but it happens. Now, I talked about home inspections. Have all of you seen a home inspection before? What they look like?
I have.
Yes,
have?
I have.
You have? Everybody else? No? All right. Well, I'm going to go through this one. So most home inspections kind of look the same. They have similar information in them. This one here was one of our old files that I used from back in 2021. I eliminated, blacked out certain information to protect the innocent. They usually have a photo of the home on the front, and they have a table of contents usually. And then you're going to get, they have a definition section where they'll show you how they code certain items that are immediate concerns for safety and should be dealt with, things like that. And here they've listed some. And they have stuff that have further evaluation. They even give you tips on things that you should save, that your client should start saving money for. You know, if the roof has X number of years left on it, they might tell you, start putting away money now, because you're probably going to have to do a roof replacement in X number of years and things like that. But there's lots of items on this house, as you could see. This house had a pool, so they're quoting Senate Bill SB 442, the Pool Safety Act. The pool spa has less than 2 of the 7 recommended drowning prevention safety features listed as safe, so on and so forth. And they're telling you exactly what the problem is with this swimming pool. Gives you a scope and definition. Now you notice here, this inspector says that he's a member of CREA, California Real Estate Inspection Association, and or ASHI, so on and so forth. There are 4 major accreditation groups for home inspectors. One of the things about lining up home inspectors that's kind of important is it's never a good idea to have like one home inspector that you always tell a buyer to sign up with and pay and arrange to do your home inspection. If you are specifically picking the home inspector and that home inspector messes up, royally, and there's some liability there, you're going to get dragged into the liability. Best way to do it, the best of all ways to do it, is to give the client the website addresses for the 4 major accreditation bodies and let them search for Sacramento home inspectors and interview and pick one of their own. Then they can get that information to you. You can set up the home inspection. The other way you can do it is give your client a broad list of many home inspectors and their contact information, assuming they are CREA certified or ASHI certified or whatever, and let them pick one off the list and then schedule that appointment. Doing it that way lessens the liability for you, for the brokerage, because it's your client picking them, not necessarily you. And before I move on the rest of this home inspection stuff, there's one important thing I want to bring up. When you're representing a buyer and you're coordinating the home inspection or the pest inspection or roof doctors coming out to look at the roof or anything like that, one of the things you have to realize is home inspectors have to get inside the house. And those inspections usually take, for that house on this picture, it was a 3-hour home inspection. And that's pretty typical, 2.5, 3 hours for a good inspection. And they look at everything from, the roof to electrical sockets to grounding in each electrical socket and all that good stuff. And you'll see as I show you some of the photos later on, just how detailed they get. But one of the things you need to remember is, we are all members of MetroList MLS, and we all have access to the Supra electronic lockbox system. If we're representing a buyer and we coordinate a home inspection, it is our job to let the home inspector into the property. And here's the kicker. You can't just leave the home inspector there and say, oh, by the way, lock up when you're done. That doesn't work for MetroList rules, and it usually doesn't work for the listing agent either, or the seller. When you somebody have a question? No, okay. When you open the door to let that home inspector in the house, you need to stay there while they're doing the home inspection. So you or an agent on your team or something like that. You can't just open the door, let them in, hand them the lockbox cup with the key and say, when you're done, lock it up and put that back in the Supra. Doing so it's actually without permission of the listing agent and the seller is a violation of the MetroList rules that you agreed to when you signed up. And it's also a violation of the Code of Ethics. And you can end up getting a fine for doing something like that. You could potentially lose your rights to participate with MetroList. So what I generally would do is if I'm working with a home inspector, I would bring some work with me. I'd sit at a table in their house and I would do my work. I might have my laptop with me if I were so inclined. My last few years of selling real estate, I was in law school, so I used to bring my case books with me and I would study while I was there. But the other thing I would do at the house is while I'm in the house, if I'm representing a buyer, what a great opportunity to walk the house and do my agent visual inspection disclosure. You want to take your time with that and do it right anyway. What better opportunity if you've got 3 hours to kill? So do that while you're at the house. And that works out perfect timing because as a buyer's agent, you are supposed to complete your AVID and give it to the buyer during their inspection period so that they can review it before their inspection period expires. The whole purpose of that AVID, which is kind of like your inspection. You're not doing a detailed dive in the house like a home inspector would, because the state only requires that you describe things that you can see with your own eyes based on your experience only as a real estate professional. It doesn't assume that you're a contractor and you should spot any all major defects, but it does say if you walk into the living room and you see discoloration on the ceiling, that you make note, discoloration on ceiling of living room near sliding glass door, or scratches on wood floor in dining room, or chipped paint on door frame outside front door. Those are the types of visual observations that you might make. You don't have to crawl up on the roof. You don't have to crawl under the house. You don't have to go into the attic. None of that stuff. Just walk around the house and make your observations on the form. What better opportunity for you to do that than during the home inspection when you gotta be there anyway? So keep that in mind. Moving on through this inspection, and you can see this one, he's a member of CREA. It conforms with CREA standards of practice. And then here's how they code their stuff. Safety concerns are in red. Further evaluation is in, was that purple? Budget to replace, that's orange. Corrections recommended, recommended upgrades, items specific to drowning prevention. It's all there. And then let's see if we scroll down here. So he's divided it into sections. They talk about foundation, basement, and underfloor areas, and they list anything that's relevant, if it's okay, if it's required repairs, so on and so forth. And then as you get far, and he does that throughout the house, but then you get to a point right here, he's saying there's an uneven surface at the entry. Let's see, he talks about some cracks and gaps on the stucco. They do, like I said, they're very detailed, cracks and gap at trim of entry. As you can see, there's good reason why it takes so long to do this on a normal house. Moisture damage at front of home. This is their job. So,
Just real quick question.
Yeah.
I have seen agent's name and information on an inspection report. I'm assuming a client can ask you to do the work, and is that okay?
Depends on how it's done. Okay. A lot of agents, they have well-established relationships with certain home inspectors. Those relationships are great. The problem with those types of deals can occur after the fact. If there's a problem with the home inspector and it turns out the home inspector missed something, and if there isn't any kind of a mediation or settlement in the interim, then and that client gets an attorney and there's a lawsuit, they're going to say who procured the home inspector. And if it's the agent that procured the home inspector, then we're probably going to get dragged into it as well. Like I said, it's better if the buyer procures their own home inspector. And that's not to say that on those inspections that you've seen where the inspector lists the client's name and the agent's name, that's not to say that the client isn't the one that procured the inspector and just put the agent's name on the report. A lot of times they do that so they can kind of co-brand and but what's important is how was that inspector originally located and procured for the buyer?
Thank you.
It's not a problem having the name on the same report. Now, speaking of the inspectors and the buyers, what I typically do, and I don't, John, I know you've done this a lot. I don't know what your process is, but what my partner and I always did is one of us would meet the home inspector out at the property. We stay there, as I said, for the entire inspection. We would find out at the beginning from the inspector how long you think it's going to take. And typically they'll say something, well, looks like I'll be done by about 3 o'clock. I say, great. We're going to ask our buyers to pop by the house about 2:30. That way, when you're done, you can go over the highs and lows of the inspection report with them, answer any questions they have. You'll still get them the full written report, but at least this way, and so here's the deal. If you see something in writing, when a home inspector writes something in a report, they have to verbalize that in a way that shows they are properly advising the client of a specific defect with the house. The way they put that into words may trigger some fear in that buyer, because they have to be kind of black and white in the way they present something. But if that inspector is able to talk to the buyer face to face, they can explain it to them in a way that doesn't scare the hell out of them. Unless, of course, they need to get the hell scared out of them. I mean, there might be a situation where a home inspector says, you should not buy this house under any circumstances. This is what's wrong with it. And I think there's foundation problems and this and that and the other. If you're going to buy it, you need to get a structural engineer's inspection done, blah, 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 blah. It's rare that you run into a situation like that. Not to say it can't happen, but it's rare. What's more likely to happen is there's going to be, every house has problems. And what the home inspector needs to do is point out the problems. But if they can actually talk to the buyers and say, well, I think the biggest problems with this house, might be the safety issues with the pool, given you have a, small kid. I think if you're going to buy the house, first thing you need to do before you move any of your family in here is have the pool safety issues dealt with. And so they're explaining that to the buyer instead of letting the buyer go home, read the report and get the, bejeebies scared out of them, thinking, oh my gosh, this place is totally unsafe and blah, 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 blah. It's kind of like if the, what is it, John, is it the PEX piping that's had all the problems?
High-tech
Kitech?
high-tech plumbing.
Yeah. So, house has Kitech plumbing, and every bit of the Kitech plumbing in the house is perfect. There's no problems with it. But the inspector notices one potential connection where there could, possibly be a problem. Well, if he puts it in his report, he's going to say this house has Kitech plumbing, which has been known to have leaks and blah, blah, blah. And I discovered this one, and he has a photo of it that says, this one looks like it's a defective connection, blah, 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 blah. Well, that might scare the heck out of a client if they just saw the picture of that and read that in the report. But if the inspector is explaining to him, look, I see houses all the time with Kitech. Everything in this house looked fine, except for this one little connection that I think needs to be addressed before it becomes a problem. That is a little bit different way of explaining and a different way for the buyer to understand it. And maybe, I don't know if I explained that as well as I wanted to, but hopefully you got the point. So anyway, I would have my client show up. Inspector goes through the high and lows of the inspection. Oftentimes I would say to the inspector, okay, now, there's a lot of stuff that's going to be on your report. Having seen what you've seen, do you think, is this something that you would recommend for a member of your family to buy, for example? And, usually it's yes. I've had one where they said, hell no. But That's what I want the inspector to do. But a home inspector is going to say, hell no, I'm not going to put my family in this place. I don't want my buyers buying it. And it's better to know now before you close than before you close escrow, or, now before you close escrow rather than after. So, I love this house. Anyway, so you can see this is kind of generally what home inspections have in them. Let's see here. This one you can see, I mean, this is pretty typical. This one goes out to 40 something pages. Oh, this is the pest inspection. Sorry, I went too far. So this home inspection was 36 pages. And just so you know, the buyers did buy this house. This one, and they're still there and happy there.
Nice.
This next one, this is a pest inspection. This is not for the same home. And this is typically what the first page of a pest inspection is going to look like. The inspector is going to go out there and they draw a diagram of the perimeter of the house. And then within that, they have lots of letters and numbers. And all of these letters and numbers that you see here correspond to a description of some form of damage. Now, pest inspectors break out damage into one of two types: Section 1 and Section 2. Section 1 pest damage, it runs a gamut. It goes anywhere from dry rot through termites, beetles, fungus, any of those types of things. Section 1 damage is the stuff that may require treatment and fixing before a lender will lend on it. Not always, but oftentimes. On a VA deal, yeah, it's going to have to be dealt with. Sometimes on an FHA deal, if it's really obvious, the FHA appraiser will require a Section 1 clearance. Conventional loans, it's iffy, depends on the lender. Now, this particular house, I should say, this particular pest inspection, I probably should replace this with a newer one or a different one. The pest inspector with Pinnacle that did this got lazy. When I say lazy, is normally Pinnacle will bid how much it will cost for them to come out and remedy all this stuff. In this particular case, he got lazy and said, upon additional request or something like that, they'll give a bid for most of the stuff. So it's not the greatest example, but I used it anyway. So I already talked about Section 1 damage. You also have Section 2 damage. Section 2 damage or Section 2 issues are conditions that, if left untreated, could turn into Section 1. So the example would be, sold a house in Roseville a while back, and you've seen the houses before where they let the ivy grow up the side of the house and across. Well, that's what these homeowners did. But the ivy has roots that drill into the stucco. And so at this particular place, the pest inspector noted it and said, look, you need to get somebody to get rid of this ivy and then, repaint the side. Otherwise, it's going to turn into Section 1 damage where moisture is going to start getting in and things like that. So that would be an example of Section 2. Another example would be if the homeowner planted a garden, say, on the side of a stucco house, and they built a planter box there, and the dirt went rose so high that it was over the stucco in the planter box. Well, that dirt can allow moisture to soak in and under the stucco and can cause dry rot. So that might be called out as Section 2 damage.
Termite, yeah.
But again, Section 2 is not the stuff that is of immediate concern. It's just a condition that, if left unabated, could lead to Section 1 damage. Also with Section 1, people think of pest inspections and they think, oh, it's just termites. Well, no, it's dry rot. It is termites. You have subterranean and you have drywood termites. Now, the subterranean termites, those are the ones that are treated pretty easily. Pest inspectors will come out and they'll just inject some stuff into the ground, or they'll drill holes in the cement sidewalk or around the house, and then they inject the stuff in and then fill the cement back in. Those are fairly easy treatments and they aren't too expensive for a company to do. The real bad ones are drywood termites, because drywood termites require the house to be tented. I don't know if you ever remember driving around and seeing the big circus tent over the house and the house is being fumigated. That's usually because it has drywood termites or it has beetles or something like that. And that's a big deal. It's expensive. You've got to move basically out of the house for a couple of days. You got to move all your food and pets and stuff out. And then, everybody in the neighborhood knows you got this bug problem. So, and that's what gets really expensive. So moving on with this pest inspection, I told you about all the letters that go around it. Might note here too, you see this, where are we going here? Report number 42054 with Pinnacle Pest Control, and this is their firm number. Every pest inspection that you ever see is going to be identified with an individual report number. And every pest inspection that is done in the state of California, a copy has to be uploaded to the pest control board, and it's going to sit with them for 2 years. So as an agent, if you're ever out in the field and you see a sticker in the garage or in a closet or in a furnace closet somewhere that says, inspected by Pinnacle Pest Control on such and such date, and you're working with a buyer and the seller in their disclosures doesn't turn over a copy of a pest inspection to you, they're withholding documents. And that should be dealt with by following up with the listing agent and saying, hey, I know an inspection was done here by XYZ Pest Control, and we didn't get a copy of that pest inspection when we got our disclosure package from you, and see what they say. If the listing agent says, oh, I never got it from the seller, can you check with them, please, and get us a copy? If that still results in nothing being turned over, you can always go to the pest control board, give them the name or the street address of the property, and they will be able to look up that inspection report and get it to you if it's been within 2 years. The reason I thought of this is my former business partner had a case about a year ago now. She was representing a buyer, and she was walking around the house doing her AVID, and she found in a closet a sticker for a pest company. She asked the listing agent about it, and in that particular case, the listing agent, we found out later, was a bit shady. She said, I don't know anything about this. And she looks around a little bit more and finds another sticker that says the house had been fumigated, the Big Ten. Listing agent claims she knows nothing about it. It was within the last couple of months. And so she ends up going to the pest control board, as well as calling one of the pest companies that she found the sticker on. And they said, oh yeah, we've been out there treated it 3 or 4 times trying to get rid of drywood termites. and we were working with the owner of the property. And so it turns out the seller and maybe the agent was lying about it. Lots of, pest treatments done to the house. Seller failed to disclose, agent failed to disclose. In that particular circumstance, she ended up advising her buyer. She said, look, if they're lying about this, God knows what else they're lying about. I think you should cancel. And they did. But you just gotta know what resources you have that you can go to. In this case, the pest control board is the ultimate say, because they're going to have a copy of whatever reports are done for 2 years. They'll keep them. And then the other thing you should be aware of, I talked about all the different areas of concern that they'll point out in these inspections. If you got here, by the way, for those of you who tuned in late, you'll find a link in the meeting in the chat window. If you'd like to download a copy of whatever I'm showing here on the screen, you can do that.
Thank you.
It's not required, but you should be able to get it there.
Easier.
So moving down through the report, they usually divide the different types of damage, section 1 and section 2. Most of these companies, as I said, will bid the work. Thing you should realize is, even if they, unlike this company who didn't bid a lot of it, when they do bid it, it's always going to be much more expensive to use the pest company to repair the work than it would be to get a contractor in there to do it. Contractors will oftentimes be substantially less expensive. The only difference is if you use a contractor to do the pest repairs that are noted, in order to get a clearance, you'll still have to get the pest company to come back out, and they will charge a small fee to come back out there again and look over the other person's work, make sure it was done. Now you can see here, like, remember I told you about the item numbers referenced on the drawing? They're right here. So they say, item 3A, faulty grade condition was noted at the planter on the front side of the structure. And then they give a recommendation, reduce the grade in the planter to correct the faulty grade condition. That probably would have been a section 2 item. We'll see in a second here. Let's see. Let's see. I'm going to come back to the stuff I'm bypassing in a second. Here we go. Yeah, 3A, section 2, and they said bid on request. Like I said, I thought this guy was a little lazy. He did bid on request for a lot of them. 8A, whatever that was, he actually put a bid for them to do the work. Going back here, they go through for every letter designation and every number designation. You will see an explanation of what that is and their recommendation for taking care of it. So 4B, fungus has damaged the 2x4 bottom plate at or in the exterior structure. Recommend remove the fungus damaged wood. If no further damage is exposed, repair, replace, blah, blah, blah. Prime paint only, property owner is responsible for painting. And then they declare it's a section 1 item. So if this were a VA buyer, this would be one of the items that would be required to be done. And they go through all the items like that. It's kind of the same thing. And then if they're going to use any chemicals, they'll explain the chemicals they're going to use in order to treat it and give that proper warning and stuff. So that's the pest. And you can see here, the only stuff they bid on in the section 1 total $1,250. And then if the seller or the buyer wants to do that, they have a method of payment and an invoice. Now, once you've done all your inspections, whether that's, a home inspection, a pest inspection, or a home, pest, roof, sewer, whatever it is, there may come a time when you want to submit a request for repairs to the seller. And this is the form you would use. You can have multiple requests for repairs if that's what's, that's what the stars present to you. But you're going to start with number one. And I don't need to tell you how to fill in the upper part, but these forms are very flexible. Buyer request, and you can use any of these sections. Let's just say there were 4 or 5 items in the home inspection that were considered safety concerns. You could list them right in here. Check the box, buyer request that seller prior to final verification of condition, i.e. final walkthrough, repair or take other specified action for each item listed below or on the attached list dated such and such. So you could list them here if you wanted. If you wanted the buyer to clear section 1 or section 2, you could deal with it here. Let me give you my take on the idea of requesting repairs versus requesting credits. If you're on the buy side, either repairs or credits might work out for your client. If your client is getting a loan, though, some loan programs have maximums on the amount of a credit a buyer can get. So if you've already gotten, let's just say, in the contract negotiation for your buyer, you've already gotten a 3% credit for recurring and non-recurring closing costs. Depending on the loan program that they've qualified for, they might not be eligible to get any additional credits. So if you're going to go a route where you're considering asking for an additional seller credit to the buyer as part of a request for repairs, what you might want to do is reach out to your buyer's lender first. Talk to them, tell them what you're planning on doing, and ask them, if I were able to get an additional $3,000 out of the seller as part of a credit for in lieu of repairs being done, would my client be able to use that in reducing costs on their loan? And just make sure it works for the lender that is handling your transaction. More often than not, you'll probably be okay, but just check just to be sure. Nothing worse than backing down off of your position about some condition issues because you're now getting cash, and then you get to the closing table or the loan docs and estimated settlement statements are being prepared, and all of a sudden the lender comes back and says they can't use that credit. There's not enough room left in their loan program. Imagine how your client would feel, and they'd probably be a little ticked off at you. So just pick up the phone, make sure it would be okay before you commit to that. If you're on the listing side and you receive a request for repairs, if I were you, I would always advise my seller, unless it's something like scrapping a water heater, or which should be done by the seller anyway, or replacing a smoke detector, or recocking a window, simple to do things like that aren't likely to lead into other problems. Unless it's something like that, you should always be pushing back with your seller against doing physical repairs to the property. And the reason is pretty simple. If, let's just say there was Section 1 pest damage, and it had to do with siding on the house, and the buyer submits a request for repairs and says, I'd like you to replace the rotted siding on the right side of the house that was identified in the pest inspection. And your seller says, okay, fine, I'll take care of that before close of escrow. Well, the seller gets their contractor out to the house, and they pull off the rotted siding, and now they go down the rabbit hole, because behind the rotted siding was, it appears that rats got in there and started chewing up electrical conduit wires. And so now you got to replace electrical stuff that was behind the siding, as well as the 2x4s that were behind there. And you just start going down this rabbit hole. And what you thought might be a $800 expense to deal with the rotted siding has now become a $2,000 expense to also deal with electrical and framing behind the siding. So it's always better if you can get, if you can negotiate in lieu of repairs, I'm just going to credit you X amount at closing. Clear on that? Now, from the buy side, might be better for the buyer to have them actually do the repairs. So this is kind of situational depending on who you're representing. But even on the buy side, buyer might need the extra cash, gives them more cash to deal with other things they'd rather do on their house instead of having to make repairs after the close. Right. But if you're going to request a credit, this is where you would put it here. When you submit the request for repairs, this is a good time to give the seller all of your home inspections and whatnot that you've done. You attach those right to those PDF files right to the request for repairs when you send it over to the seller. Let's just say it's an FHA or a VA deal where the lender actually requires these repairs to be made. In that case, you don't really have a choice usually. And that's where you will make the request right in here that the seller take care of those problems. Now, if seller agrees to all of buyer's request or some of buyer's request and buyers accepts seller's partial agreement down below, A, buyer removes the investigation of property contingency, or except for the following. And it gives you a little flexibility on what you do here. Essentially, though, they're asking you to remove contingencies if the seller agrees to the repair request or credit. Buyer's going to sign here. It's going to go to the seller. Seller can either respond on this form here by saying they're going to do it all, or they'll check partial and they'll say they'll do all except anything they're not going to do, they would note here. The other thing, and I've seen this more, they can also respond back on a form RRRR, which is this one right here, which gives them a little bit more options in terms of how they respond. But they can respond either on this form or they can respond on the same form. They're flexible, they can do either. June of 2022, they added this section right here, specifically that covers the buyer removing those contingencies identified on the attached contingency removal form. So the buyer, scratch that, the seller can send a contingency removal form along with their request and ask the buyer to remove them, assuming the seller agrees to do whatever the buyer is requesting. And then we have, after the seller responds to the buyer's request, if they stick to this form and don't jump to this RRRR, there's a spot for the buyer to respond to a partial or conditional agreement by the seller to do the repairs. And that's right here. Pretty simple stuff. This is that form RRRR that I was referring to. Covers the same stuff, does essentially the same thing, looks a little bit different, but it's pretty self-explanatory. The form RRRR actually gives an expiration for the buyer to respond to the seller. So it's basically, they put it into kind of a contract term. If the buyer doesn't respond to the seller's offer by a certain date and time, then the offer by the seller is revoked. Not to say it can't be reestablished, but the seller is no longer obligated by the buyer simply signing. And this is where the buyer would sign on that. And then we have the contingency removal number 1. I wanted to talk about the relationship between contingency removals and a request for repairs. A lot of agents, they kind of think of them as being, hand in hand. And what you have to realize is the duty of the buyer to remove their contingencies on certain dates, depending on what was agreed to in the contract, is totally separate and distinct from the buyers making a request to the seller to repair something or credit something. What do I mean by that? Let's just say the buyer's inspection contingency was 17 days. They took the standard default number in the contract, which was 17 days. And the buyer side had trouble getting their inspectors lined up, and they finally got all their inspections and stuff back, let's just say on day 16. They look at them on day 16, and the evening of day 16, after going through all this stuff with their agent, the agent talks to them about maybe doing a request for repairs. And if you're an agent, you're talking to your buyers. When you do a request for repairs, it's not meant to be a laundry list of every single item a home inspector finds or a pest inspector finds. What you're generally going to do is you're going to look at stuff that's like health and safety. I mean, think about it. You're buying a used house. It's not going to be in perfect condition. There's going to be dings in walls. There's going to be, problems with leaky windows. Maybe insulation is getting not so great anymore, so on and so forth. So you're going to find the health and safety items. Those are typically the stuff that you would expect to be in a request for repairs. But you're at day 16 now, and you meet with your clients and you write up a request for repairs, and let's just say it's got 5 items in it. And that evening, you send the request for repairs over to the listing agent. Now, bear in mind, the next morning is going to be day 17. That's the date when your client was supposed to, when they contractually obligated themselves to remove their inspection contingency. Now, the seller, from their perspective, they want their contingency removal. The buyer, from their perspective, well, I don't want to remove my contingencies because I just sent a request for repairs. And if I've sent a request for repairs and I remove my contingencies, they don't even have to consider my request for repairs because I've already removed my contingencies. I have no leverage over the seller anymore. Well, a lot of agents will delay sending the contingency removal, and their logic is, well, I'm not going to send a contingency removal. I haven't heard back on my request for repairs yet. I can wait as long as I want because I've sent a request for repairs to the seller and they haven't responded yet. That is a categorically incorrect way to think about it. You have to remember there are 2 different things. On the one hand, buyer contractually agreed to remove their contingencies on day 17. On the other hand, the buyer's thinking, but I've sent a request for repairs and I need a response on that. Well, the reality is somewhere in the middle. And the reality is this: just because a buyer sends a request for repairs, there is no legal or ethical duty that a seller even respond to it. They don't even have to acknowledge they've received it. They certainly don't have to accept it. When a seller gets a request for repairs, they have a couple different options. They can say, okay, fine, I'll do everything. They can look at it and say, screw you, Mr. Buyer, I'm not doing anything. Or they can say, okay, well, I'll do item 1 and 2, but I'm not going to do 3 and 4. I'll accept items 1 and 2. I'll reject items 3 and 4. Or 4, They just don't respond. They can do any one of those options. But at the same time, they have a right, based on the contract your buyer signed, to get their contingency removal. So if your buyer doesn't remove their contingencies because they're waiting on a response for their request for repairs, the seller, if they so desire, they can send a document to your buyer called a notice to perform. A notice to perform can be sent for any contingency that has not been complied with on that date. And they can actually send the notice to perform 2 days prior to the end of the contingency. So on a 17-day contingency, they could send the notice to perform on day 15, so that once they reach day 17, if they don't get their contingency removal for that particular item, the seller could, if they wanted to.
Yes.
Sorry, did somebody say something?
So to cancel, right?
Yes. The seller can cancel. And it doesn't require seller and buyer to both sign the cancellation. If a seller is canceling based on sending a notice to perform and the buyer not responding to the notice to perform and removing that contingency, it only takes the seller's signature to complete the cancellation. It's a unilateral cancellation and it is completely legally valid. Once that happens, there is no recovering the contract, reinstating the contract, bringing back the contract. A contract is either live and executory, or it is canceled and completely dead. If the buyer and seller choose to write a new contract and sign it and open up a new escrow, well, that's another story. But as to the existing contract, once that seller sends the cancellation, buyer's out of the picture.
Bruce,
Yeah.
is that 3 business days or does it matter?
Well, with the notice to perform, it's 2 days. It's 48
2
hours.
days.
48 hours. Okay. Now, with a demand to close escrow, which is what you have to do if that's what the seller would have to send if the buyer failed to close escrow by the contracted close date. Demand to close escrow requires 3 days.
Thanks. And that was business days, right?
Yeah.
Or okay.
Yeah, it would roll over to the Monday.
Thanks.
Okay. Or unless Monday's a holiday, Tuesday. Okay. So the lesson I want you to take away from this when you're representing a buyer is, you've sent your request for repairs and, you're right in that cusp of a period where your contingency is expired also. If you want to, strategize and try to leverage and, play chess with the listing agent and the seller and game this thing out to try to get them to bend to your request for repairs, that's all well and good. But the moment they send you a notice to perform, you need to understand your time periods and how far you can continue to push this without complying with removing that contingency. I would say you wouldn't want to go more than 24 hours before you either have that heart to heart with your buyer and say, look, you can continue to wait, trying to get them to negotiate with us and engage with our request for repairs. But just know that anytime after today, they could actually send a cancellation. And once that happens, you're dead. You're no longer under contract. So it's okay to do that and to play that game, but have an honest conversation with your buyer client and let them know that this is what could happen if we continue to do that. Because realistically, they're going to have to make that decision. Remove the contingency And realistically understand that once you do that, they're probably not going to agree to your request for repairs, or continue to push for the request for repairs and risk cancellation. All right, all clear on that? Now, when you remove a contingency, I love this form because it is so flexible in the ways we can use it. You can have it, first of all, it talks about the ramifications of the buyer removing their contingencies. And then section 2, you can remove it allows you to remove specific contingencies, whichever those are that your client wants to remove. Section 3, basically you're removing them all except whichever ones you check. And section 4, they can remove all their contingencies at one time. So this form, any way you want to use it, it's perfect for you and your client. It's very flexible in the way you can use it. And anyway, you get the idea. And of course, they sign it and date it and send it over to the other side. So you may have contingency removal number 1, number 2, number 3, depending on how slowly you're removing them or what the contract required. And with that, I think we're done with the material. Any questions?
So what is the buying as is? Does it mean you're not
What is buying as is?
right? What I mean, yeah. Do you still have to do all of this?
Okay. So,
Sorry.
so just so you know, under California law, every sale is as is, subject to the seller's right to full disclosure about any material defects with the property. All right. Now, you have to understand, you can write into a contract, I agree on buying the property as is. Now, if you say as is, you can still give yourself the right to do inspections and so on and so forth. But you limit your ability to cancel based on conditional issues. Now, if you said I'm buying it as is, and then you get a transfer disclosure statement from the seller, and within the disclosure statement, there's a material defect with the property. Now, let's just say Riza, I'm going to use you as a guinea pig here. Let's just say you are Asian, right? And it's very common knowledge. Asian home buyers, they have a particular problem with buying a house that somebody has died in. I've had numerous Asian clients who have told me, no, we're not going to buy this. Somebody died in the property. Now, personally, it doesn't bother me. My last house in the Bay Area, the former owner died in the master bedroom. My wife and I didn't care. But there are certain people that do have feelings about that. And they do not want to buy a house that somebody died in. So you get the TDS from the seller and you're going through it with your client. I'm going through it with Riza, and Riza looks and sees that. And now you're already under contract, but this is the first time you've seen the disclosure. And you say, well, no, I'm not going to buy this. There's no way. And you would be allowed to cancel, because that would be a material defect, even though you stated that you were an as-is buyer.
Mm-hmm. And obviously, as an agent, you will do your visual inspection regardless, always, right?
Oh, yeah, of course.
Yeah.
And, that's usually, I'm not going to see something on my visual inspection that is going to be a big surprise that wasn't discovered in a home inspection. I think in one occasion that I can recall, home inspector went through the house. There was no issues with discoloration on the ceiling. By the way, we never, when you're doing an AVID, we never use the M word, mold, because we're not skilled biologists. We're not skilled scientists. We can't say what's mold and what isn't. We call anything that we're not sure about, We call it discoloration.
Dis-
All right. So
no leaking, just discoloration.
yeah, there's discoloration on the ceiling of the kitchen right below the master bath. Okay. Something like that. But I think in one occasion I recall opening up a closet, a small, like coat closet, and I saw discoloration on the ceiling that was not caught by a home inspector. So that might be a material issue that we're talking about here. So that's that. Did that answer your question?
Yes, thank you.
Anything else? No? All right. Well, if I don't have any other questions, thank you for attending.
I'll do a quick one.
Yeah.
I didn't know we were finishing. So for those city inspection, a specific inspection like City of Woodland that require the fire, sprinkler inspection.
Yeah.
Obviously, the seller would have to do that for the sale, and the same rule will apply, right? The buyers will have to do their own, or you recommend buyer doing their own.
Time
Okay.
out. Why did you say obviously the seller will have to do that?
City requires to do that for sale of
The
the
city requires the inspection to be
an
done.
inspection.
So
Correct.
why did you say the seller will have to do it?
Oh,
I'm not saying you're wrong.
yeah,
I'm saying
yeah.
you assumed
For
that
the
seller would
purchase,
have to
yeah.
do it. That could be subject to negotiation. Now I know for a fact that it has to be done in the City of Woodland if there is a fire safety system installed in the house. There has to be a test done. Now, if I were knowing that, if I'm representing a buyer, I might try putting it into my purchase contract. Seller will pay for fire marshal's certification of sprinkler system. And if they agree to that in the contract, then the seller is responsible for it. If it's not addressed in the contract, then it's a dispute potentially that the seller and buyer side have to iron out. So I would try to get it into the contract to say the seller is responsible for it. If I'm on the seller side in Woodland, and it's not addressed in the purchase contract, I might have the seller counter. Buyer pays for fire marshal certification of a fire safety sprinkler system.
Right.
So it depends on what side you're on.
Right.
Hammering to get it into the contract on who's going to pay for it.
Right. I was thinking as a seller's agent, I don't know, usually you want to do all the inspection ahead of the game, and this way is an easy transition or transaction, let's say. But I
don't remember what the time limit is on how long those are good for. I mean, maybe it's 60 days, maybe it's 9, maybe it's 6 months. I don't know. But if I'm working for the seller, I'm going to try to pass as much of the expenses onto the buyer as I can. And if I'm working for the buyer, I'm going to try to pass as many on the seller as I can. So, it depends on on which hat I'm wearing when if I'm writing the offer or if I'm reviewing the offer with the seller.
Thank you.
So, anything else?
Thanks.
All right, then. The last thing that I will mention to you before we go is, I kind of wear the hat here of a broker that works in, the Sacramento, Yolo County, Placer County area. A lot of agents, even though they work here at KW in our offices, a lot of agents will sell properties in the Bay Area, in the foothills, other areas where local customs and point of sale requirements might be different. So bear in mind that if you're going to be doing business, for example, in San Mateo, I think San Mateo now, it is a requirement that prior to the close of escrow, a video sewer line inspection be done. And if that's not done, it's not going to close escrow. Now, the matter of who's going to pay for that can be negotiated in a contract. But just bear in mind, if you venture into other areas, if you're planning on venturing into other areas, make sure you talk with somebody that works in that area that can give you some advanced information on if there are any local point of sale requirements for inspections that are going to have to be done. Because the last thing you want to be doing is getting to the close of escrow date, and all of a sudden you learn, oh no, I forgot to do this, or this needed to be done, right? But there was one other thing.
You still contact the city and county as well, right?
You can contact the city or county. Better bet would, contact a KW agent that does a lot of work in those areas, in one of their local offices, and ask them. Go to somebody that's been doing a lot of business there.
Mhm.
Okay. Anything else?
Thank you.
Thank
All
you.
right. Thank you guys for joining me, and I'll see you next week.
Okay,
Thank you.
bye-bye.
All right.
Take care.
Bye-bye.
Bye.